Good evening and welcome to the first Social Justice Reading Room given by the Association for the Study of African American Life and History. We are so excited to have you join us tonight for this time in the reading room to hear from our presenters and discuss issues of social justice. Tonight, the instructions will be to listen, to use your chat. We see that some of you have started introducing yourselves and conversing in the chat, which is great. We'd love to hear where you're from, how you heard about our session, and anything else you want to do to introduce yourself to your fellow participants. Also, if you have questions, we would prefer if you put the questions in the question and answer box. And so there's a Q&A tab on your screen. If you would go in there and type your questions, we'll be sure to see them. Although we will be monitoring the chat for discussion and question items also. And then finally, if you raise your hand, we'll see if we can get back to you near the end of the session. There'll be a panel and there'll be questions and answers provided within the panel. And later at the end of our reading room, we'll bring in some of the questions that you're asking our panelists. I want to thank Howard University and the Mellon Grant for providing ASALH with the funding and the opportunity to broadly share social justice concerns and issues and bring together the community at large toward addressing these issues. And so without further ado, I'd like to introduce the president of the Association for the Study of African American Life and History, Dr. Evelyn Brooks Higginbotham.
Thank you, Michelle. And welcome everyone to the ASALA Social Justice Reading Room. I am your guide into this virtual space for exploring important books and articles on social justice. And ASALA is proud to host its reading room and this inaugural event as part of Howard University's Social Justice Consortium, which is funded by the Just Futures Grant of the Mellon Foundation and under the leadership, this consortium, under the leadership of Howard History Professor, Dr. Nikki Taylor. ASALA has designed the reading room such that it is a comfortable environment for not only academics, but an inviting space for people from all walks of life. In this virtual room, you will be introduced to and gain access to authors whose publications in the form of books as well as articles speak in compelling ways to the continuing struggle for racial equality in America. In this first opening of our reading room, this is our debut, we are so excited to feature the book Justice Deferred, Race and the Supreme Court by Orville Vernon Burton and Armand Derfner. The book's authors have a long and illustrious record as defenders of racial justice in America. And I see we have Professor Burton, but we still need Armand Derfner to come on video. Thank you so much. Here he is. The book's authors, again, have a long and illustrious record as defenders of racial justice in America. Vernon Burton is the Judge Matthew J. Perry Distinguished Chair of History and Professor of Pan-African Studies, Sociology, and Anthropology, and Computer Science at Clemson University. And I must say for myself and for all of us who knew and remember the great civil rights lawyer and later federal judge, Matthew Perry of South Carolina, it is truly an honor to hold an endowed chair that bears his name. Vernon Burton taught for 34 years at the University of Illinois, where he is now emeritus, and he is a prolific and prize-winning author who writes about race relations in America, and equally important, as you'll hear, uses his knowledge as an expert witness in civil rights cases. In fact, when Julian Bond was president of the NAACP, Julian once stated that Vernon Burton had done more pro bono work for the NAACP than any expert witness. And we're also so proud to represent and to present the legal profession in Armand Durfner, the co-author who for more than 50 years has been a civil rights and constitutional lawyer. His victories in several cases before the Supreme Court helped to shape the Voting Rights Act and also helped to desegregate state legislatures and state university systems in the South. In addition to having a law firm in Charleston, South Carolina, Armand Durfner is also scholar in residence in constitutional law at the Charleston School of Law. So let's begin. I want to start off in a special way with you, Vernon, because you've been an ASALH member for many years. I remember you're telling me once how important ASALH was for historians of all races and ethnicities, to anyone who taught or teaches, researches, or publishes on topics related to the contributions and experiences of people of African descent. And this was especially important and needed during the years when the other professional historical organizations did not include topics about African Americans or even include African Americans as members, as we see today. And yet ASALH was always unique through its Journal of what was called then Negro History and the Negro History Bulletin, and of course the ASALH conferences. We were the organization that not only promoted social justice and wrote about social justice, but practiced it. So Vernon, could you share some of your thoughts and memories with our audience about ASALH and why it was and continues to be important when we think about social justice?
I'm happy to, and you'll just have to stop me because there's so much to say. I don't want to take the whole hour or 2 hours even to talk about it. But I think it's important for people to remember why Carter G. Woodson started the Journal of Negro History. It was a place where people could publish articles about race and African Americans. And we forget that two of the most important early books on Reconstruction, which went completely against what became the dominant thread of our narrative of Reconstruction, had already been published, but they couldn't be published by academic presses, refused to do them. And they were first serialized in the Journal of Negro History. It was A.A. Taylor's work, which is really classic. We also forget that archives were not open to African Americans. I ran into some really interesting situations that bring it so home. And, in South Carolina, really African Americans couldn't come into the South Carolina archives or into the South Caroliniana Library. until well after the 1960s. When I was writing a book on Penn Center, I discovered that Penn Center had offered their papers to the University of South Carolina with one stipulation, that the papers be open to everyone. This was 1963, which meant that Black scholars could go look at those papers, and they refused them. That's how they ended up at North Carolina. And one of the great stories of the profession is John Hope Franklin, when he was researching his dissertation on the antebellum free African American in North Carolina, went to the archives, and they said he could not, in fact, sit in the reading room where all the researchers were. So the archivist, with John Hope's insistence, arranged for him to come back in a couple of days and put him inside the archives at a separate desk, at which point then, of course, which sort of sounds like early affirmative action complaining, all the white scholars complained that he got special treatment because he got to go back where the archives were. But it's a point to be made that these archives were so segregated. And secondly, they didn't even want to have African-American records. They weren't interested in them. They were interested in the records of the planter class, that is the white planter class, and how they perceived slavery. So even when I began as a graduate student writing, we were sort of told there weren't sources. Of course, now we know that there's just so many sources to get at, but that's part of why the association was there. And one of the things that I benefited from in going to these early meetings, which I really started as a graduate student at Princeton, early 1970s, maybe as late as 1969, but the amazing scholarship that was presented at the meetings at the time, it has just been, you know, extraordinary. The people who actually spoke there. You had reminded me, of course, that in the 1940s, this legal giant, Raymond Pace Alexander, presented there. Judge Constance Baker Motley of the NACP and NACP Legal Defense Fund, so important, in fact, in the case that here Judge Perry argued to get Harvey Gantt into Clemson, the first integration of any public school in South Carolina since Reconstruction, because they were integrated during Reconstruction. University of South Carolina was presented in the 70s. Of course, Leon Higginbotham, who I got to know, presented there from the 1970 and they almost all of their speeches, their research has actually been published in what was then the Journal of Negro History. So it's an amazing opportunity. One other quick story, just to give you the example, it caused a furor when C. Vann Woodward sort of negotiated to get John Hope Franklin to give a paper and integrate the Southern History Association, because African Americans couldn't stay in the hotels in the South at most places where the Southern met, and special arrangements had to be made about dinners and things. So that's part of what the association was. What was wonderful about the association, it had welcomed white scholars. So it was integrated early on with many white scholars who were there to learn about it. One other quick story, and I'll stop, but my first publication, I guess not the first, but the first really serious publication for a journal, being a historian of the American South, I sent it to the Journal of Southern History called Race and Reconstruction. And there were two comments that came back when it was rejected. One was, "This is Marxist folderol," which hit pretty hard for somebody who was a deacon in the Baptist church. And the other was that Francis Butler Simpkins, an actually very good Southern historian who helped sort of turn around the historiography. But the other statement was, well, Francis Butler Simpkins was South Carolina, and he didn't believe that Reconstruction was successful and that African Americans were actually changing and making a difference and things like that. And I thought, but I'm from 96 South Carolina. It's not even that far from Edgefield. So it was a venue where people could publish, in fact, on race relations, on African-American history. And it's always been sort of my favorite conference in terms of the intellectual exchanges. And it also points out the importance, I think, of getting rid of segregation, and so that ideas can be exchanged between different groups. Now, I can go on and on and on if there's something you want to know particularly about ASALH, but it's been fun to see it emerge, and also to see how all the historical associations, it became something for community members. It has both a rigorous academic side, and it has something that we need in all history professions to engage the public, the communities of people who are non-scholars but interested in history, where it applied to their lives. So I love that part of it as well.
Thank you. You know, you reminded me too that my late husband, and he was a federal judge on the Third Circuit Court of Appeals, for those who might not know, Judge Leon Higginbotham, but he wrote in the 90s a very famous article called Open Letter to Clarence Thomas. And that open letter to Clarence Thomas came about when Clarence Thomas first got on the bench, and it was to kind of give him a history lesson. He first presented that at the meeting of the Association for the Study of African American Life and History. It wasn't even called Open Letter to Clarence Thomas at that time. It was called something like a legal historian speaks to Justice Thomas, but the first debut was at the association.
And I remember it well, and then I will promise to be quiet, but both John Hope Franklin and Judge Higginbotham together, you know, sat down with me in an ASALH about how important it was to do this work as an expert witness, as a historian, to bring this work to the courts. And that's part of the reason why I continued and stayed doing it all those years. But the two of them at an ASALH meeting took me out to dinner and made that argument.
Yes, and I just want our audience to really recognize what a powerful book Justice Deferred is, and how timely a book it is. In fact, I'm moved by the insight that the authors bring to the topic of race and the Supreme Court. And specifically, the insight about the critical role of time and the law. And this is a theme that Armand Durfner is especially interested in. But I would just like to quote you, time is fundamental for understanding race in the United States. This is what is said in the book. And the focus on time was especially relevant to ASALH's founder, Dr. Carter G. Woodson. And so he would have really appreciated this book, because he too wrote an article, not a book, but a very important article in 1921 in the Journal of Negro History, in which he analyzed race and the Supreme Court, the decisions in regard to the 50-year time span between 1868 and 1908. And as we know, these were years that initially witnessed citizenship and voting rights through the Reconstruction amendments to the Constitution. But then those rights were soon undermined and steadily taken away by Supreme Court rulings in favor of the legality of segregation and voter disfranchisement. So just to contextualize this, Armand, do you know that by 1921, when Woodson wrote his article, he was so furious with the states' rights precedents set by the Supreme Court decisions that he began with the sentence, and I quote Dr. Woodson, "The citizenship of the Negro in this country is a fiction, a fiction." Well, the court has certainly gone through various changes over the decades since Woodson's 1921 article. But Armand, I would love for you to talk and give our audience a sense of what is different about the court's approach to race in the in that next decade of the 30s through the 70s, because those are the decades when we talk about progress. And what is the difference when we think about that time to the time that preceded it, and in fact, the time after it?
Thank you, Evelyn. And it is an honor to be here and all the work that ASALH has done over the years and the decades. And this is a wonderful example of how that work is continuing and is going to help bring us to better times. It's interesting that Dr. Woodson was writing then. What we talk about in the book is that people oftentimes think of the Supreme Court as the Palladian of liberties, the institution that ended segregation, protects the right to vote, the right of free speech, guarantees fair trials, etc. But as we point out, and it takes one of the reasons we tried to bring a broad sweep in this book, the broad sweep of history, is that those notions really date from a relatively short time in the Supreme Court's history, essentially from the 1930s to the 1970s. Those were times of progress. The 30s and 40s are often called the road to Brown. And then in early 1950s, along came Brown versus the Board of Education. And over the next 2 decades, the 50s and the 60s, the court dismantled official segregation, and with the help of Congress and the president, really did guarantee the right to vote, ended segregation in public places, and began working against segregation in private life, in employment, in housing, etc. But that all comes from the 30s through the 70s. From the time earlier, the court spent most of a century and a half really destroying those great rights. And unfortunately, I have to say that in the period since the 1970s, it's been back on a backward trail. And now that backward trail is going at a very, very high rate of speed. We start with the early period. And we're trying to give a sense of the sweep of history. And it's ironic, the first chapter is about the period before the Civil War. And we have the Dred Scott case, that the most reviled case in history, and the one that said African Americans could not be American citizens, whether they were born slaves, born free of free parents, no matter what. And then along came, after the Civil War, along came the Reconstruction Amendments, 13th, the 14th, and 15th, ending slavery, guaranteeing equal protection, guaranteeing the right to vote without regard to race. And so at that time, the Supreme Court had the opportunity to really make those amendments a living part of really what was a new constitution. And Justice Thurgood Marshall has talked about what a different change, what a new constitution came along. He talked about that in his famous speech in Hawaii in 1976 on the bicentennial. But instead of paying attention to those new amendments, the Supreme Court in the 1870s, 80s, 90s, into the new century just scrubbed those, turned their backs on the new Constitution, on the amendments. And in a sense, the cases of the Supreme Court after those amendments is in a sense even worse than Dred Scott, because at the time of Dred Scott, at least the Constitution tolerated slavery, or maybe more than tolerated it. And so you could say the Supreme Court was a little bit in tune with the Constitution. After those amendments, the Constitution said something quite different. And so when the Supreme Court kept destroying equality and kept stepping on African Americans, stepping on the federal government's sometime attempt to help, it was not only, it was just out of tune, it was violating the Constitution of that day. And it wasn't until into the 19-teens and around 1921, and Professor Woodson could not have perceived it at the time, but there was a little bit of turning around. So starting about 1911, as we talk about in the book, that's when the Supreme Court sort of hit bottom. And when they said the grandfather clause was unconstitutional, the clause that said people whose ancestors were eligible to vote back in 1860, which meant only white people, they didn't have to take a literacy test. They didn't have to qualify or do anything like that. They could just vote. In 1915, the Supreme Court threw that out. It was the first time they had ever said anything about the right to vote, protected the right to vote in any way. And so Dr. Woodson in 1921 was there at, in a sense, what amounted to the dawn of the beginning of progress, but it still was not visible. And he fortunately lived to see the progress that came along in the 30s and 40s. Unfortunately, he died in 1950, almost the same time as Charles Hamilton Houston. And so he did not live to see the breakthroughs in the 1950s and 60s. That also meant he's not been here to see the backward steps in the years since, say, the mid-70s or the latter part of the 20th century and these 20 years in the 21st century. But it's that sweep of history that Dr. Woodson was reflecting on is what we try to present in this book.
You know, that's so important. I'm thinking, I gave a talk at the Duke Law School about this in 2010 when I was a visiting professor there, that when Carter Woodson wrote that piece in 1921, what's interesting is that in the 1940s, and Vernon alluded to this, Raymond Pace Alexander spoke at the conference. And he started talking about the victories that were leading up to what we think of as Brown, but not just the school victories, but the locomotive engineers and these other victories that Charles Hamilton Houston had been leading the charge. And I think what you saw between the 1920s, that 21 article in the journal, and now this 40, like around 45 or so article in the journal by Raymond Pace Alexander, you could see that the courts had changed. You know, he spoke with an optimism that obviously Woodson had no basis for speaking. And so that time is really important. I mean, when you think about the time now, though, what would you say about where we are now in terms of time? You know, for people who could see the courts change, in my generation and all of your generations, we saw the courts change. But now we're seeing the courts going back in another direction. We have a generation of people who would have never seen the upward trajectory, you know, the liberal trajectory. They are seeing only a kind of post 70s. How would you think about that period? Either one of you can say something.
Well, Armin and I have talked a lot about this, and we just hope we don't come down on the same side the same day, because it is very discouraging. It's really discouraging. And one of the things that I see happening is, what worries me is the incremental steps that were taken by white Democrats after Reconstruction. Small things like moving polling places like we're doing now, reducing the numbers where people vote, all of these little things, until they as a party became the dominant party in basically what was the former Confederacy. And then they disfranchised a whole group of people. It wasn't all at once. It was those small little laws that they were able to get changed. and what a difference they make, because voting is so critical.
Yeah, and this really brings me, Vernon, to this. I'd like for you to talk about, both of you, if you want to, but to talk about how you discuss voting, because voting rights is at the core, it's at the very foundation of race and the Supreme Court. And it's not that people vote for Supreme Court justices or they vote for federal appellate and district court judges, but those judges are nominated by the President of the United States, voted on by the US Senate, and the presidency and Senate seats are elected positions. So who we vote for makes a really big difference. We cannot not vote. And even at the state level, many judgeships and prosecutor positions are elected positions. So voting rights are just simply crucial. And court decisions about voting rights are crucial. So could you talk about that subject as discussed in Justice Deferred?
Right.
And it goes, so, Armin, did you want to go ahead, or you?
I'll start, you pick it up. You can hit the ball home. Yes, the assault on voting was really the beginning, along with segregation, of the descent into Jim Crow. Because as soon as Reconstruction ended and the old guard took control again in the former Confederate states, the rebel states, the first thing they did, along with segregating, was getting rid of the right to vote. And the US Supreme Court, in half a dozen cases around the turn of the 20th century, said, yes, that's perfectly okay. And the states did the most god-awful, bald, unashamed, dishonest things. And the Supreme Court said to all of those, that's perfectly okay. And in the civil rights movement, with the end of the white primary in 1944 by the Supreme Court, with Judge Waring's cases in South Carolina dealing with the white primary, and then with Congress stepping in and with the Voting Rights Act, it seemed like the right to vote was recognized and protected. And yet now in this century, the 21st century, what we see is that people who are against progress are attacking the right to vote, and the Supreme Court is going right along with it. So we all know the Shelby County case a few years ago, where the Supreme Court cut the heart out of the Voting Rights Act, did it with dishonesty. Actually, the opinion of the Chief Justice actually misquoted, took some key words out of an opinion, out of an earlier opinion, to make it seem like he had support, when in fact the opinion he was quoting said just the opposite, but he took words out that made it seem like that it was different. And now, just in the last several years, the court again has treated voting as something that isn't worth anything. And so people in many of the states are now gearing up, people who are against equality, against progress, against the modern world. They somehow have a handle on some of these state legislatures, and they are just working overtime to make sure that people do not vote. They are attacking our democracy in the state legislatures just as much as the people who invaded the Capitol. And so what we are seeing now with the Supreme Court's complacence is almost a repeat of the god-awful days of the 1890s and 1900s. And we need to know how important the right to vote is, because the people who are attacking it, they know how important it is, and that's why that's where they go.
So
let me back up to something you started with about the importance of the vote. I don't think a lot of people understand that, at least for the federal judges and for the Supreme Court justice, they are appointed for life. And one of the things we do in this book is show even how that's changed, because people used to retire. People used to move off. People used to go do other things, and they live longer now. So all of that's mathematically argued in the book. But we are not a parliamentarian form of government. It's a winner take all for the US presidency. That's why the stakes are so high. And that president gets to appoint Supreme Court justice and district courts, which may be more important in some ways to the actual life, but you can just think about what happened. I mean, one of the things we do is sort of play a little game in terms of the appointments that were made and how it would have changed history probably. I would rather argue there's a contingency in history, which we try to show throughout the book, but instead of just playing games with it. But one of the classic ones, of course, is the death of Thurgood Marshall, who had said that he didn't plan on retiring. He planned to be, shot dead in his bed by a jealous husband at the age of 120 or something. But when it looked like, in fact, that there was no way that the first George Bush was not going to be reelected. He was so sick. His dearest and closest friend, William Brennan, had retired. He was almost the lone voice. Here's a man who hardly ever lost a Supreme Court case that he argued for the NACP and NACP LDF. And then when he finds himself in the latter years on the Supreme Court, what you have is that he is on the losing side of the arguments of the decisions almost every time. But because he retired, in fact, what no one saw Ross Perot coming. The popularity was so high after the first Iraq War, but Bill Clinton won, and Bill Clinton wouldn't have had an appointment to have been a Democrat. So instead of Clarence Thomas being appointed, there's a lot of speculation, but Judge Higginbotham was one I'd heard a lot about.
People did say,
and I'd heard that from sources, but so many good people will think about even how that changed, because it is a 5-4 decision on what happens in the 2000 election as to who will become president, and then those further appointees, and you can sort of see where we are. But that contingency and the importance of voting, and voting even goes beyond that. You go back to Frederick Douglass, you go back to W. Du Bois, and there is the argument to my personal hero, who was from my hometown of 96, Dr. Benjamin Mays, echoed by Martin Luther King, the importance of the vote. And we think about how people died, were murdered, tortured because of their attempts to vote. It is such a precious thing that people have to vote. That's the one thing that we can do. There's a lot we can't, but we can vote. And now there are all these actions going on to not only dilute the vote of minorities, particularly African Americans, but to go back to 1898 and Williams versus Mississippi, and again disfranchise voters of color. So I think it is really critical. And for us, it really, I met Armand because of voting rights. It was in 1980 in Mobile versus Bolden in Alabama, where the Supreme Court said it didn't matter that a law kept African American having a chance to ever elect a representative, even though they were 40% of the population. It had to be shown that the intent of the lawmakers who made those at-large elections was to dilute that black vote, to have purposely done that. And I remember wits in newspaper, what are we going to do? Dig up these people from 1911 and say, did you intend to, discriminate when you wrote these laws? At which point attorneys like Armand literally, said, this is what historians do. We look at intent and purpose and understand how to get at it. And in fact, that began what, in Casablanca, a beautiful friendship that's gone on since 1980. And finally, between our discussions and sort of when the book started is arguing those things. But one thing I will say that historians should never, ever probably be prophets or predictors, but Armin and I went out on a limb, and if you look in the footnote, we predicted this last very bad case of Baranovich with Samuel Alito. But I like to link these three cases historically because historians look for patterns. Armin mentioned Dred Scott, the most reviled case. And in that case, as it moved its way up, if it had gone as the precedents had gone before, then Dred Scott would have been free. Even South Carolina would have freed someone who had had his experience. That was what the laws were at that time and how judges had ruled. But a judge said times are not what they were. And it's almost echoed exactly in Shelby v. Holden by Judge Roberts, almost the same words. And then it is very closely echoed by Samuel Alito in the very case that we predicted, Baranovich out of Arizona, where he says, you know, well, today is not like 1982 when the renewal of the Voting Rights Act comes about. And he talks about little inconveniences, and just like Judge Roberts and Shelby, and just like Judge Tony in his own Dred Scott, he totally misreads the law, particularly about Arlington Heights and what it says and how you show intent. And he talks about what I talked about a little bit earlier. Well, there are inconveniences to voting. That's exactly what was done in the period after Reconstruction, taking away a polling place, making it harder until one party gets in charge. So I think we have to be very, very alert.
But Evelyn, before we get too much into gloom and doom, let me put a brighter face on some of this. And that is, a lot of people are worried today. Where is our democracy going? What is the future? How are things now? One thing that encourages me is that I believe the Supreme Court now in its backward movement is out of step with the country, with the majority of the country. In the 1890s and the good old Jim Crow days, everybody seemed to be, every white person seemed to be for Jim Crow. So the court was just carrying on the national move. Today, I believe that a strong majority of the population in this country is in favor of progress and racial equality. It so happens that people who are against that have some of the levers of power in many of the states, and frankly, some of them are populating one of the great political parties of this country. And what they're trying to do is hold back democracy the way the king of Denmark 1,000 years ago tried to hold back the tide. I don't think they're going to be able to do it. They can do it for
Armin,
a while, but
Armin, if the people who believe in equality and we could see from all of the great Black Lives Matter demonstrations after the murder of George Floyd, it was a very diverse group.
exactly.
But if those same people don't vote in every election, that's how we lose. So whatever their sentiments are, if they don't vote, and have to do more than just simply vote at the presidential level,
Right.
because in that off-year election is when a lot of those state decisions are made, and those state decisions are crucial. You know, so we are the voice. Last year in 2020, our theme, ASALH's theme, was African Americans and the vote. And that was an important theme because it was an election year. But it has to be the theme every year.
And the theme has to be, we can do it, do not be discouraged. People are discouraged, and I think what some of these state legislatures hope is that people will be so discouraged they'll give up. Well, we're about to win. We are winning. We meaning people of goodwill. And all we have to do is remember that there's more of us than there are people who are trying to wreck the democracy. But you're right,
And
you have to move, work, and stay strong.
But that is why they're trying to do it, I believe, Armin,
That's
is
right.
exactly that, with the discovery not only that an African-American could be elected president and was, and that people registered and came out to vote when they had someone who they thought would represent their interests, but when they all of a sudden looked around in Texas and discovered that they are becoming a majority minority state, then these laws start hitting. It's a time of crisis, just like Reconstruction, just like the Civil Rights Movement, all of these times, World War II. And I think it's really critical. I do want to add, Evelyn, it's not just there, but we as historians, all you hear about now, the new sort of cultural icon is critical race theory, which is not taught in the public schools, but this is what is motivating people to go out and vote on the wrong side. So you need to vote for school board elections as well. The vote is our only way. And we talked about this earlier. I think I would change the age of Lincoln, as I sort of concluded that not everyone were night riders and terrorists, that is, of whites and all that. The real problem was that most people who were basically good people in general were not willing to stand up for the rule of law and follow the law and that rule of law. But now I look at where we are and we have to ask ourselves, what can we do? And it is tough, because what can you do when you're removed? And the vote is the one thing that everybody can do, but also we can educate people about what's happening. I don't think people are aware of how we got to where we are and what a difference it makes.
When Dr. Woodson,
Well, you know,
was-
can I interrupt
Right.
because we're going to run out of time, and I do have a couple more really important questions. Because one burning question is the issue of the criminal justice system, and your chapter titled "The Color of Criminal Justice." This is as important as voting, and it's particularly relevant to the work that ASALA is doing with the Howard University Social Justice Consortium, because the theme this year for the consortium focuses on race and incarceration. So in that chapter, you provide a variety of perspectives for understanding this topic. So could you both talk a little bit about the color of criminal justice?
I'll talk just a little bit, and Vernon can fill in, but we talk about a number of different aspects that all fit together. Whether it's the death penalty, whether it's the incarcerated state, the huge jump in incarceration, 3 strikes you're out laws, and of course police issues, police misconduct. All these fit together, and they're a way of sort of keeping another form of control over people, so that it sort of won't. They operate as a barrier to progress, to racial progress and racial equality. And so we talk about all those, we link them together, which is something important. And we also talk, frankly, specifically about the issue of police misconduct. We have a specific suggestion that we are waiting for people to pick up, and that is that there ought to be a rule of municipal and state liability. Right now, if a policeman shoots somebody, that policeman could theoretically be sued, but the Supreme Court has set up barriers that make it almost impossible. But what should happen is that if a policeman does something that's wrong, then the city, the county, the state, they should have to pay. And if that happened, there would be remedies for people, and pretty soon the government would get the point. If these things keep happening, then they need to do something about it. It's going to cost them in the pocketbook. So we try to bring a sort of an approach that talks about various aspects of what really is one problem, and that's why we put them all in a single chapter because they're not separate items.
In fact, in some ways, of all people, we're echoing Booker T. Washington, who says the color that matters is green. And if people have to pay, insurance companies and others are going to demand some reforms. So we have to be smart, I think, in how we attack these problems. There's been such a racial bias that's gone back. I mean, one of the things I like so much is stamped from the beginning is the idea that starting with enslaved people who we would think of as freedom fighters who run away from enslavement were seen as, of course, criminals. And so you have that criminality, and so many people have written about this recently. I think it's very important to understand this cultural idea that you even saw it coming out with the Black Lives Matter movement as a critique of even George Floyd and others, or even just recently the Ahmaud Arbery cases. They try to sort of throw this idea that a Black man would be obviously a criminal if he's a mile and a half from his home jogging in a white neighborhood.
One of the things I will say, I'll just say this, we do recognize, this is not a slanted or partial book. I think of this book as a very even-handed book, and nobody has accused us of partiality. And one of the places that comes up is we recognize that most police officers are honorable people doing their job. There are unfortunately a number of police and incidents that turn out badly, and oftentimes because the police officer is not qualified or shouldn't be there. But we do recognize that most police officers are honorable people. In fact, a law student came up to me the other day who had been a police officer and appreciated the fact that we recognize that there are two sides to the issue.
Yeah, I would also want to give out a shout out to the president-elect of ASALH. My term as president ends at the end of this month, at the end of December. But Marvin Delaney, who is the president-elect, has written a book on, in fact, it's a pioneering study actually on African-American police officers, looking at the complexity of their role. Before we turn it over to our audience, I did want to just have you both talk about how historical knowledge can play a direct role in the fight for social justice, both inside and outside the classroom, because you have been engaged in taking historical information to court. So could you just talk about, some of the cases, and some, I think, Armand, you even said at one time you were arrested in court, but just talk about some of the cases that you brought knowledge and made a difference or tried to make a difference.
I'll go ahead. There are some interesting cases of little known people that we talk about in the book, and one of them I think you've written about, Evelyn, and that's the case of Catherine Brown. In the 1870s, Catherine Brown was a Black woman took a railroad train from Alexandria to Washington, D.C. She had a ticket for the ladies' car, and they threw her out. They put her in what they call the colored car. She brought a lawsuit, and the railroad defended on the ground that, well, the cars were equally safe, equally comfortable, equally desirable. So even though they were separate, they were equal. The Supreme Court in the 1870s had no difficulty. They rejected that argument. 9-0. They rejected it. They said separate but equal. They didn't say separate but equal. They said that's a crock. And yet 20 years later, the Supreme Court said, oh yeah, separate but equal. Oh yeah, that sounds very good. They paid no attention to their own precedent. So that's one that I like to think of. The other one is excuse me, a woman named Miss Mary Hamilton. In 1964, the Supreme Court had a case. This was a woman, black woman, came originally from Cedar Rapids, Iowa, went south as a civil rights worker, was arrested in some demonstration. And when she went to police court in Birmingham, the prosecutor said, "Well, now, Mary, where were you?" And she said, "My name is Miss Mary Hamilton." And he said, right. "Now, Mary, where were you?" She said, "I will not answer your questions until I'm addressed properly." What she meant was addressed the same way white women were. She was held in contempt, fined $50. Excuse me. The Alabama Supreme Court upheld that case, and the U.S. Supreme Court took that case. Now, the U.S. Supreme Court doesn't, they're usually dealing with multi-billion-dollar cases and gigantic issues, but they took the case of this $50 fine because the Supreme Court of that day in 1964 understood how central the issue of courtesy titles was to white supremacy. And the Supreme Court understood that, and they reversed that case. And one of my favorite parts of the book is we have a picture of Miss Mary Hamilton looking very demure in a beautiful sweater and beautiful pearls, looking like the lady she was and the lady she wanted to be treated as. So that's another case that I think is an interesting case. It's a telling case of what the Supreme Court of that day understood.
Well, I think history is so important. It's almost like religion to me, and I believe in it because part of where we began with question one from you to me about the association, ASALH, our history has been so distorted, so told wrong, so told from a wrong perspective for so many years that people believe this nonsense. So one of the things that we can do, at least in the courts, is to tell the truth. And I'll give you a good example. Fairly recently, right after Shelby v. Holder, it was within minutes that the Texas legislature put in their in-person voter ID law, which in fact had already been judged by a federal court to be discriminatory against minorities, and probably they didn't quite go that far to say intentionally. And so I was expert witness for the LDF, and by showing the pattern of all those laws that went back to things like the poll tax and the literacy laws and all of those, and every single time the people who were putting them in, it doesn't matter if they're Republican or Democrat or Martians, actually, it was a power in party. And every time they would say it's because of voter fraud. So we did that through, and then show that the courts in every case had found that they were racially intentioned and motivated. And by doing that, laying that out as expert for the LDF, the judge found, in fact, that the in-person voter ID law was intentional once those facts were laid out. And Armin and I did a case together where it was very easy to show that school boards, people hadn't really looked at the evidence, that school boards, there were how many of them, Armin? Maybe eight. 4 of them were majority African-American, 4 not. Guess what? They changed once blacks started to vote. In fact, after ASALH Jenkins ran on Johns Island, and actually, though he didn't win the election, came in head of a white person, that in fact they changed it. So all of those that were African-American were appointed by the all-white power structure council, whoever did at the time. So those that were in white areas got to elect those. And even just showing, people hadn't even noticed this kind of evidence. And that's the kind of thing we can do as historians, is show that. But it's also educating the public that critical race theory is, what does it have to do with teaching history, the documents, the facts? It's not even done, but we need to educate the public. And we can do that as historians. Everybody can, particularly those of us who are trained to present this evidence. And it's very hard for judges to, no matter what their own political persuasion or what their political party, it's very hard for them, I think, to look at the evidence and then rule the other way. It happens sometime, but I have been pleasantly surprised at some judges, including the first case Armin and I worked at, the very first one that started in 1980. I was told this judge was right of Genghis Khan. We will never win. All we can do is put the record down, Vernon, I was told, and then we'll appeal it. It was one of the best rulings ever. Once he saw the evidence, he had no idea what it was like in the old Confederacy until that evidence was set out. So I think there is truth in the power of evidence, and evidence is a real thing. You know, we hear all this about postmodern history, but there's evidence. Some things happen and they can be documented and they can be used to educate the public. It was like the civil rights movement. People did not really believe it was that bad in the South until the cameras, the TV cameras and the photographers showed pictures of dogs attacking, water hoses rolling children. And I think that is part of the power of the truth. And the truth is sort of sad now as to what's happening, but we've got to get out the evidence to people.
Thank you so much. This has been just wonderful, and I so appreciate this conversation. We want to open the reading room up now to our audience. I don't know, Nicholas, or who is the person who's going to be reading some of those questions from our audience, but please do so.
Yes.
Christina, thank you.
No problem. Good morning or good evening. It's evening. We have a couple questions that have floated into our chat and in our question and answer box. So we're going to start with the first one out of our chat, which says, what do you believe to be the possibility or likelihood that we'll see real violence again around voting rights?
I think it depends partly on how we treat the violence that has already happened, particularly around the January 6th invasion of the Capitol, and also that convoy of trucks in Texas that ran the busload of voters off the road. If there's a real sense of punishing those people, of standing up for the rule of law and for law and order in the right way, then I think perhaps it will not happen. The problem is that there's a lot of people out there who believe crazy things and may do crazy things. But I think a solid enforcement of the right is crucial for that.
And the Supreme Court has not helped by making the sort of worship of guns as part of our national religion with their rulings as well. But I want to add to that one thing, because I think it's been there and it's still there and it hasn't gone away. And particularly white people like to think, well, you know, terrorism, domestic terrorism began with 9/11. But African Americans in the former Confederacy, at least until the Voting Rights Act of 1965, lived in a terroristic society where people could just do most anything and get away with it. And if they had not turned over the evidence in the Ahmaud Arbery case, thinking they were helping their case with that horrible video of showing 3 white men chasing, or 2 white men chasing, the third man videoing a black man jogging, then we don't know if anything would have ever come out of that basic lynching that happened. Thank goodness that, you know, justice was served.
Are there other questions?
If not, Evelyn, let me just go back to something you mentioned that we haven't talked about, and I'll just talk about it for a minute, and that's the importance of time. One of the things we talk about in the book is just that, because we've had slavery and Jim Crow in this country from about the mid 1600s, and it didn't really end until the middle third of the 20th century. So we had 300 years of slavery and Jim Crow. That's a dozen generations if you figure 25 years a generation. We've only had 2 generations since that time of trying to overcome that. And so if you think 12 generations is 12 times that mothers and fathers have built into their children's education a life of inequality, of a dual society, white supremacy. And you don't overcome that right away. As I say, we've had 2 generations. We've made progress that Matthew Perry said this himself in a conversation. He and I were having lunch one day, and he said, I have seen things that I never dreamed I would live to see. So we need to take the lessons of time and first learn, because it took 12 generations to implant those crazy ideas, the work cannot be done in 2 generations. It will take a lot more time and a lot more generations of children of goodwill to get the job done. At the same time, we have made a lot of progress, so we can't just be discouraged. So looking at time is another way of that we tried in this book to give some perspective, to bring to sort of help stimulate people to do thinking about that.
Armin, why don't you add to that if no one has a question too about the reading of the law, whether it is
I think Nicholas you're gonna have a question, Nicholas, too, just before we go. I don't want to.
Yeah, we have several other questions.
Okay, could you just read them and then? Yeah.
Yeah, can you hear me? I'm sorry.
Yes.
Yeah, we have several other questions from our Q&A section. Dr. Annette Davis had a 3-part question initially that asked, can you talk about what history teaches us about voter apathy? What does history teach us about how we can help millennials choose to vote rather than practice a modern day version of youth voter apathy? And finally, does Mississippi provide a model?
Vernon?
I can take part of that because in an earlier Texas case on redistricting, back when Representative DeLay figured out after they had already redistricted for the census in 2000, he could grab 2 more Republican seats with gerrymandering. I was an expert witness for both LULAC and the NACP getting to work together. That's another issue of something that's changed, that if people of color can see from different ethnic backgrounds and groups that they have certain issues in common that they can work together on. But it was interesting because this judge was the first time I had ever in my life heard a judge identify themselves or him or herself as one political party or the other. But he turned to me and he said, Professor, this is when I was on the stand testifying, and he said, Professor Burton, you know, I'm a Republican, but I am very worried about democracy. How can democracy work when young people don't vote? How can we get young people to vote? And I think he was really onto something, and it worked very nicely because the next time I testified in Texas, I was able to say, the last time I was here, a judge who said he was a Republican said to me, how are we going to get people to vote? And now I'm here testifying in a case in which, you know, Republicans party in control are trying to find ways to stop people from voting. What has happened in between? And I said, we see what has happened in between with the move into a majority minority state. So that's one thing we have to encourage. And I think, again, history pays that lesson. when people don't vote or when people are stopped from voting. That extremism comes out. So once most African Americans were stopped from voting, look at the extremeness that came out of the old Confederacy and these sort of politicians that we sort of have caricatures are now. The extremism that we're seeing today is partly because of the way that one party can control, and the way you get attention is to get more and more extreme there. So I think that's one lesson of history to encourage people. The others I've said already is what people went through to get the vote. Beatings, death, everything. It was sacred. I remember it was Ben Mays who said about the anti-lynching law, I don't worry about an anti-lynching law, give us a vote, we'll take care of it. It is your way of having a seat at the table. So I think that's why it's so crucial. And we can see some of the results that are happening now from when people didn't go out to vote, particularly in the Supreme Court.
Thank you. What's the next question? I want to try to get as many of our audience questions answered.
No problem. This one's still on our voting topic that we're talking about right now. And it says, with the gutting of the Voting Rights Act, gerrymandering and the other voter suppression strategies are running rampant, what recourse do Black voters have when their voting districts in most elections have been systematically uncompetitive?
You get Stacey Abrams to come and help you. But I think what she did in this last election was remarkable. I mean, but look at all the effort and stuff that went in to that. What ASALH did about voting for the election, of getting people educated and understand the importance of the vote. But that's not to make light of it. It really is disfranchising people. It's not only diluting their vote, but they're disfranchising them and making them more extreme. So it's very difficult. That's why the presidency, which is that winner take all, unfortunately, the Electoral College doesn't necessarily mean the person who gets the most votes will be able to do it. But we have to keep lobbying our politicians or those lawmakers. That's one thing. It's not just voting, but also letting them know how we feel. I think Armin's exactly right to say that there are more good people, more people who want to do the right thing, more of us than there are of them. But lawmakers need to know that. And
but you know, I was just
all
thinking
these symbolic terms too, that, you know, the cultural wars that are so bad.
In
But you
Congress
know,
right now, go ahead.
I know just one small thing about the millennials and the voting, or if you are in a district where it has been so gerrymandered that your population in that district is small, but at the presidential level, your vote still counts. So you can't give up. You just cannot give up, because the votes that go in the state, your little district might be different. You might not get the congressperson you wanted or something, but you will get, if enough people vote, that number, that crucial number for the presidency from your state, because the Electoral College is still going by the state.
But you can also work for coalitions, and it's not the best way, but sometimes it's better to try to get the least worst devil than the worst one. And I think that those votes matter in that way too, and the coalition. But the other thing to do is call out what's going on, make it public knowledge.
Congress is considering something called the Freedom of Speech Act right now and the John Lewis Voting Rights Act right now, and they're both stalled because of the filibuster. And so what you should be doing is lobbying however you can. Lobby your congressman, your mayor, your minister, your League of Women Voters, your newspaper, to get those bills passed, get rid of the filibuster and get those bills passed, because they would do a lot to end political gerrymandering, corruption of campaign finance, and a whole bunch of other things.
You know, and just another point about the Voting Rights Act. You know, a lot of people don't realize that it had to be renewed. You know, so people thought, okay, well, Voting Rights Act of 1965 and it's all over, but that's not what happened. So it was renewed on a regular basis. And it's only been recently when it has been rejected. Because even with Republican presidents earlier, we were getting the Voting Rights Act to go through, even under George Bush.
And Ronald Reagan, who didn't really support it, and it was the jewel of legislation of voting, though they had opposed. In fact, what is so shocking about Shelby v. Holder and then now the Bronovich case is that the Voting Rights Act was renewed early and almost totally bipartisan, and almost 100%. I believe all senators supported it and almost all representatives. And then the Supreme Court still said, oh, well, they don't know, you know, the representatives don't know what they're doing. It's a very strange situation we find ourselves in.
What's the next question?
Gene Tenney asks, I am totally with Armand's optimism about the reality of what most Americans want. But can the panel comment on the fact that so much of government policy is not determined by voters and taxpayers, but by multinational corporate interests with no loyalty to any county, much less to democracy and lobbyists and campaign contributors, rather than legislators, are driving the drafting of bills that duly get passed in their interests. This is much of what causes so much cynicism among younger would-be voters who elect to stay home and allow the enemies of democracy to triumph by default.
Yeah. I'll just say quickly, and I'll turn it to Armand, you know, the 14th Amendment, it was put in literally because of African-American former enslaved people to give them their rights. And yet 80% of all cases are, you know, for corporations and businesses. It's been turned on its head and used against affirmative action in ways that is just so corrupt. But it seems like you sort of answered the question. I mean, that is an issue. And Citizens United is just, it's hard to believe what the court can do with something like that. But Armin, you want to tackle that?
Well, yeah, Citizens United was a corrupt decision that was intended to make sure that the multinational corporations keep on pouring money into and submerging people's votes. But multinational corporations also respond to people, customers, other people like that. And so it's not time to give up on that yet.
A good example is Coca-Cola when they, after Martin Luther King Jr. got the Nobel Prize, they were going to have a big dinner, and you know the white business weren't supporting it. So the head of Coca-Cola said, you know, we're multinational, we can go anywhere, and if you're not at that dinner, we will. And then everybody turned out for the dinner. They do respond to that kind of pressure and don't want us to be seen as the bad guys. If we saw some of that happening with the rioters, I mean, it looked like it was going to happen with Congressmen when some of the big money bags pull their money back for those who were not willing to do the right thing. But it didn't seem to last very long.
The reason South Carolina doesn't have a Confederate flag flying over the Capitol now is because the NCAA said we're not going to have a basketball tournament in Greenville. And the NCAA did that partly because of the influence of people working on the colleges and Black athletes.
Good point.
And the NACP had long-term boycott.
They spearheaded.
That's right.
Another question from our audience. We only have 8 more minutes, so.
Oh, okay. I think we are seeing the U.S. imitate Brazil with browning America with an elite white oligarchy running the country. I am wondering if you've done transnational comparisons throughout the Americas. Both the US and Brazil were slaveholding societies. What does the judiciary look like comparatively?
Well, we both have dictatorships, or we both had dictatorships, right? With the president of Brazil also getting the virus, just like the short time dictator here getting the virus. I don't know what the fate of Brazil is, but I think Werner would know more about this than I do. But I think the different roles of intermarriage and the role of how slavery ended in the two countries makes some kind of a difference.
But you bring up a very good point, I think, and something we sort of have as a sub-theme. There are three branches of government. And the legislature has often stood up, as it did with the renewal of the Voting Rights Act in '82, when it thought the court was wrong and sort of did the will of the people. The executive plays a role of enforcing laws and things, and suddenly the Supreme Court starts doing laws. So I think we need to know our government a little bit better. We need to know the Constitution. We need to know those laws and follow them through. Not just the judges, but people need to know them and let the judges know and let the legislators, they know the laws and what the law is and call them, you know, the idea that we are a nation of laws that have founding principles that say all men are created equal in that very sexist language, but that has some ideals that we've been working to. And I hope we'll have an opportunity. I'd like to read the last paragraph of our book, because we got pretty depressed at times too and fought back and forth. And it goes to some of our themes. At some point, I want to get the other question if we have time, but I think it does speak to the next generation as well as the generations that came before, that do give us hope that we can do something and make a difference.
We will give you the opportunity to read that section at the end. But if there are other questions, we do have about 6 more minutes. Nicholas or Christina, are there other questions from our audience? Because we want the reading room to be a place where you can engage these books and their authors.
Yes, we have a good amount more questions, so I'll try to sift through some of them. To either gentleman, would you say that Reconstruction never really ended?
I would say that, and I've made that argument in several books, of course, that Reconstruction is the most progressive period in the history of the United States and the most misunderstood and the most mischaracterized over time. But when I wrote about Ben Mays, his parents had pictures of the Reconstruction leaders there. You look at Attorney Boulware here in South Carolina, and you take back who his family were and others. The heroes were African-American legislators and champions, someone like Robert Smalls and others. And that comes right forward through to the day that both in the courts and outside the courts, people fought for the right to vote and for equality. And, Reconstruction is now much more broadly interpreted in the West, but it really begins in the former Confederacy. And it has continued there. It's a remarkable story of people who never gave up, of people who fought for justice, even when white Americans weren't that concerned, and eventually at least became partially successful. And we thought with the Civil Rights Act of '64 and the Voting Rights Act of '65 had been successful. But the very first picture in our book is one of Thurgood Marshall getting off of the train in Charleston to argue Briggs v. Elliott, which is a case he argued and really was a central case of Brown v. Board. And we had already exasperated Harvard with our changes so we could make more changes in the text. But I found a place that I really love this quote where Thurgood Marshall said, "Sometimes I get tired of saving white people's souls." And, you know, I think that's the other side of it, of what this struggle did. It was, of course, for African Americans, but it was also for the soul of America and continues. And one of my absolutely favorite stories, and I might even start crying, as Armin will tell you when I start to tell it, but is of Thurgood Marshall and Justice Brennan. And it's the 1980 Reagan Revolution. These two great social justice warriors, dear friends. And when Thurgood Marshall was first appointed to a federal job and then for the Supreme Court, on Judiciary Committee was Strom Thurmond from South Carolina, who just gave him a horrible time. I mean, he just drilled him and, are you a communist? Don't you associate, on and on and on. Well, Ted Kennedy had been the chair of the Judiciary Committee, and he was very favorable to voting rights. And so William Brennan runs up, they both are in their robes, judicial robes, and they come out and he says, "Is it true? Is it true? Is it true that Strom Thurmond is now chair of the Judiciary Committee?" And I just see these two men, Brennan is a tiny, small man in stature, great in heart and intellect. Thurgood Marshall is not only great in heart, but he's a giant of a man. And he puts his arm around him and they march off back to their chambers. And to me, it symbolizes these two giants of racial and social justice and fighting the good fight go back for their last fights, but they never gave up. They kept on. I think that's inspiring to the rest of us as well.
It is. Thank you. We are really coming to the end. Christina, do you have something for us here? Because we've got to close out.
Yes, we have one final question, which is kind of two questions because two of our communities asked a similar question, and it's about education within our system and understanding our full history. So the first question says, do we have any talking points or plans to issue guidance for those facing the anti-CRT rhetoric at local government and school board meetings and to combat state legislation that would prevent teaching our full history? And the second part to that was, is there anything that ASALH and its southern branches can take to promote that educational history during these critical times?
The attack on critical race theory is not new. It's just got a new name. Think of all the years and decades, generations, in which the dominant theme was that the Civil War was not about slavery. We didn't have slaves in the North, all kinds of things. So it's nothing new. I don't know that there's any new weapons against it, but I'm just reminded of a case some years ago, back in the 1970s, a book by a great sociologist, Jim Lowen, who died recently, had a picture of a lynching in it. It was turned down as an approved textbook by the Mississippi State Textbook Board, and the state textbook man on the witness stand said, "Well, part of the reason we turned it down was that there's a picture of a lynching in it." And the judge broke in and said, "Well, it happened though, didn't it?" And the textbook man said, "Yeah, but it was so long ago." And the judge said, "This is a history book, isn't it?" So we just have to keep remembering that people have been trying to steal history. And this is actually Vernon's job to stop them from doing it. People have been trying to steal history for years and generations. And so this is nothing new. And unfortunately, the fight against it never ends.
Well, it's more complicated, I think, Norman. I agree with everything you said, but right before COVID. In fact, you were there as part of the conference. I did a conference, Lincoln's Unfinished Work, and the last day, Jim Lowen and I did a workshop, all-day workshop for school teachers. Heather Cox Richardson did our keynote for the teachers, and they wanted to, public school teachers, how do you teach about this difficult subject of race and the history of race relations in the schools? And the teachers are dying to learn how to, they want to. And so many of these teachers, since the attacks on the critical race theory that's kind of, have been in contact with me about what do? We want to do this. You know, we want to use the primary sources to show people these sort of things. So I think this is rather critical. It's done, but this is trying to regulate teaching and quote thinking is very, I mean, I think it's different. I think it's very serious. I think it's very scary. You know, you don't want people to know your history. You don't want people to learn to think critically. So I
do think, you know, as I listen though, I want to put the two of you together though, because I'm telling you, when ASALH was founded and for much of our 106 years, we had to play the role not only where there was no history
that's right
being taught, but we had to play the role where there was this horrible history that said Black people had no history or no history worthy of respect. So we have been fighting this for 106 years. It's just so surprising that after 106 years, we're still doing what Carter G. Woodson had to do. But if Carter G. Woodson can do it, we certainly can continue that legacy, and we are committed to doing that.
I was going to say exactly that. It goes right back to the first question of why Carter G. Woodson founded the association and the journal and continued that fight and things to give the alternative.
They had it a lot worse and they never gave up.
Yeah, they didn't give up because they were fighting for the truth, and the truth will set you free eventually. So now, can you read for that final part for us to close us out? I want to thank everybody for coming to the reading room. We will be having more reading rooms, and we are just so eager to have more of these conversations with all of you. Why don't you close us out, Vernon, with the paragraph?
And I think this does give us some hope at the end as we struggle with it. In a 1951 poem, the Harlem Renaissance bard Langston Hughes asked, "What happens to a dream deferred?" History, shaped by the court's unfolding interpretations and limitations on right, tells us that justice has been deferred too long. Abraham Lincoln challenged us, "Determine that the thing can and shall be done, and then we shall find the way." We take inspiration from the young people who will be writing the next chapter. In 2019, 2020, the U.S. Youth Poet Laureate Amanda Gorman gave readings around the country of a poem she had been commissioned to write for Independence Day. In her performance at the American Academy of Arts and Sciences, Gorman, an African-American woman from Los Angeles, who was a student at Harvard, explained that she sees American democracy not as, quote, something that's broken, but as something that's unfinished. Rather than falling prey to discouragement, she speaks of being audacious and taking up the mantle of our founders and playing her role in finishing their work. In her poem, Believer's Hymn for the Republic, she declares, "Every day we write the future together."
Every day we write the future together. Thank you so much. And thanks to all of you. Michelle, I'm going to call you back in to close us out.
And we want to say thank you as well. And there's a website that you can go to. It's got all of this on it and a lot more.
It's been a
What's the
privilege to be
website?
here.
Armand and Vernon, what is the website?
Go ahead, Armand. Justice
Justice hyphen
I
deferred
say dash, yeah.
Justice-deferred.
.clemson.edu.
Oh, .edu. Okay.
And we're putting that in the chat right now.
Right.
There's also been a request for your email addresses. Is it okay if we put that in the
Yeah,
chat?
please
as
do.
well?
Yes, of course.
Can
and
you
we're-
say it and we'll type it in at the same time if others want to take it down?
Well, we'd love to keep the conversation going.
Okay.
Go ahead, Armand. Well, mine is V-U-R-T-O-N, that Boston accent, that's not a B, that's a V like Vernon or Victor.
Okay.
V-U-R-T-O-N at Clemson, CLEMSON.edu.
And my easiest email is Derfner, just Derfner, no initials, at Comcast.net. Not .com, but .net.
Armand, can you repeat that again? I'm sorry.
Derfner at Comcast.net.
Okay, got it. All right. I really want to thank you all for being with us tonight. This has just been a wonderful way to close out a year of work on social justice, again, as a part of a grant that we received. Sorry about that loud noise. That the grant we received from Howard University, in partnership with Howard, on the Mellon Just Futures grant. And want to remind you, Sylvia Cyrus, the executive director of ASALA, has been putting information in the chat, which has been great. But for those who didn't see it, today is Giving Tuesday, and your contributions to ASALA make this type of activity possible. So really want to encourage you at this last hours of Giving Tuesday to go online and give to ASALA. That's asala.org, so we can continue these and all the other wonderful programs that we do. Dr. Higginbotham, thank you so much for your leadership in this last year of ASALA, of your presidency, but we know that you're going to be with us in these reading rooms going forward and leading us through these fabulous discussions around social justice and where we go from here with not only history, but trying to find that positive outcome. Vernon Burden and Armand Deferred, this has just been wonderful. You've brought us full circle. We've learned about the past, where we are today, how we're repeating ourselves, but we know that we can continue, and you all have given us all those inspiring words. Everyone, again, thank you for coming, and look out for our message for our next reading room and as we start our workshops in 2022. Have a wonderful evening.